Hello and welcome to the Mander Handley podcast, where we explore legal issues that affect everyday life. Today, we are turning our attention to the private rental sector and the Renters' Right Act. This is set to bring some of the most significant changes to landlord and tenant law that England has seen in decades, from the abolition of Section 21 no-fault evictions to new tenancy structures and stricter rent controls. That will change how residential property is let and managed. While much of the commentary is focused on tenant protections, landlords are now grappling with what the changes mean in real life. The Act received royal assent in October 2025, but many of its provisions are not yet in force. The government has published an implementation plan with major reforms expected to begin from the 1st of May 2026. In this episode, I'm joined by Amanda Hyam, our Head of Dispute Resolution and Employment at Mander Handley. Together, we'll explore what landlords need to know and how they can prepare. So, Amanda, what is the Renters' Right Act and why is it such a big change?
Well, the Renters' Right Act represents the biggest shake-up of private renting in England in years. It replaces the long-standing assured short-hold tenancy agreements. It removes the Section 21 no-fault evictions entirely. Fixed-term tenancies will be phased out, and the sector will move to open-ended periodic tenancies. The Act is set to rebalance rights between tenants and landlords, while aimed at improving security for tenants. It will affect how landlords regain possession and review rent.
So, when does the Act take effect and how is it being rolled out?
Okay, so although the Act became law in October 2025, none of the main provisions are as yet in force. The government published an implementation plan in November 2025, and the reforms will begin in phases. Okay, so the first and most important phase is expected to begin on the 1st of May 2026. Later phases will introduce the private rented sector database, Ombudsman scheme and extended housing standards.
How will security of tenure change for landlords?
Well, assured short-hold tenancies will be abolished. All short-term private residential tenancies will become assured periodic tenancies. There will be no fixed end date to tenancies. Existing assured short-hold tenancies will automatically change into periodic tenancies on commencement. Landlords will no longer be able to end a tenancy without a statutory reason. Tenants will be able to leave at any time by giving at least 2 months' notice. And it removes the uncertainty around tenancy length. However, it does increase risks for landlords.
So what happens to Section 21? How can landlords recover possession?
Well, Section 21, no-fault evictions will no longer exist. They're done away with completely, and landlords are going to have to rely on expanded statutory grounds under Section 8. These grounds will remain either mandatory or discretionary. Mandatory grounds require the court to grant possession if proved. However, discretionary grounds require the court to consider whether possession is reasonable. Many grounds have strict conditions and notice requirements. Court delays remain a concern, particularly where swift possession is needed. That's a real downside for landlords. Clear record keeping and compliance will be essential.
And are there any special rules for student lettings?
Yeah, so as you would expect, it will depend on the type of accommodation. Purpose-built student accommodation, known as PBSA, is expected to be exempt. These tenancies, which are granted after the commencement of the Act, will become common law tenancies, which means they will be governed by contract. But the existing PBSA tenancies are expected to change to periodic tenancies. Non-PBSA student lettings will fall within the new regime. A new possession ground will allow some student HMOs, those are houses in multiple occupation, to regain possession over the summer. Strict conditions will apply, including advance warning notices. Joint tenancies may create increased void risks if one tenant leaves early. So there's a lot of untested waters here. Landlords are going to have to be extremely careful before they set out on these new tenancies.
And how are rent increases changing under the Act?
So rent increases will be limited to once per year. Landlords must use the statutory Section 13 procedure. Contractual rent review clauses will generally be unenforceable. So regardless what it says in your tenancy agreement, it's not going to make any difference. Rent increases can be challenged by the tenant at the first tier tribunal. Rents will no longer be backdated following tribunal decisions. So the date the decision is made is the date the increase will come into effect. This may encourage more tenant challenges. Delays and uncertainty could affect cash flow and investments for landlords. And clear evidence and documentation will be increasingly important.
What new restrictions apply to rent payments and deposits?
Well, pre-tenancy rent payments will be prohibited. Only a refundable holding deposit of up to 1 week's rent is permitted. So that's where a tenant wants to secure a property. This isn't the actual deposit that you pay to protect the standard of the property. Rent cannot be required more than 1 month in advance. Tenants may choose to pay more, but it cannot be a contractual requirement. At tenancy end, tenants are entitled to a refund for unused rent days. Deposit caps remain unchanged. Deposit protection requirements continue, and failure to comply can restrict possession rights, so making it even harder for the landlord to regain possession of the property.
And what are the major changes should landlords be aware of?
Okay, so bans on rent bidding wars and advertised rent must be honoured. Prohibition on discrimination against tenants with children on benefits. New rights for tenants to keep pets with consent not to be unreasonably withheld. AWAB's law and the Decent Home Standards will apply to private landlords in later phases. That's to do with the dreadful mould situation that happened in that case. A new mandatory landlord registration database will be introduced. A compulsory landlord redress and ombudsman scheme will follow, and increased civil penalties and new criminal offences for non-compliance for landlords. So in short, landlords beware.
How can landlords prepare for the Act?
Review tenancy agreements ahead of May 2026, understand how possession grounds apply to your property, maintain compliance with safety and repair obligations, prepare for new notice and information requirements, keep detailed records of any tenant discussions, and seek early legal advice if any queries as to how these new reforms are going to affect you.
Thank you, Mander. While most of these important changes will take effect from May this year, early preparation and support are crucial. If you're worried about how the Renters' Right Act will affect your investments and how you can stay compliant, the residential property team at Mander Handley can review your tenancy agreements and help you prepare your property for these changes. Please call us on 02476 631 212.